When the Biden administration nominated Steve Dettelbach to run the Bureau of Alcohol, Tobacco, Firearms, and Explosives, a senator asked him during his confirmation hearing to define the term assault weapon. Dettelbach, a former federal prosecutor, a man nominated specifically to enforce federal gun law, declined to answer. He said he would defer to Congress on what the definition should be. The man nominated to run the ATF could not tell a congressional committee what an assault weapon is. That is not a political failure. That is a legal one. And it tells you everything you need to know about the problem at the center of every assault weapon ban case being litigated in America today. There is no single federal legal definition of assault weapon in force in the United States right now. There has not been one since September 13, 2004, when the 1994 federal ban expired and Congress declined to renew it. Every definition of assault weapon that currently exists in American law is a state-level creation. 11 states have enacted assault weapon bans. No two of them define the term the same way. A rifle that is legal in Maryland may be banned in California. A magazine legal in Connecticut is banned in New Jersey, even though both set a 10-round limit, because the exemptions differ. The Supreme Court granted certiorari on June 30th, 2026 in Viramontes versus Cook County and Grant versus Higgins, two cases that will decide whether states can ban AR-15 platform and similar semi-automatic rifles under the Second Amendment. Arguments are expected fall 2026. A decision is expected by June 2027. But before a single brief is filed on the constitutional merits, the court has to grapple with a definitional problem that has existed since 1989. You cannot decide whether a category of weapons is constitutionally protected if the category itself has no agreed legal meaning. This video is about that definitional problem, where the term came from, how the 1994 federal ban defined it, how 11 states currently define it differently, why the definitional inconsistency is itself a constitutional argument, and what the Supreme Court will have to resolve about a term the law has never cleanly defined. Let me start with where the term actually came from, because most gun owners know it is politically constructed, but cannot cite the primary source. The term assault weapon, as applied to semi-automatic civilian firearms, does not have a military origin. It does not have a regulatory origin. It traces directly to a 1988 booklet written by Josh Sugarman, the founder of the Violence Policy Center. Sugarman wrote about a strategy for restricting these firearms and laid out his reasoning plainly. He observed that the weapon's menacing looks, coupled with the public's confusion over fully automatic machine guns versus semi-automatic assault weapons, noting that anything looking like a machine gun is assumed to be one, could increase public support for restrictions. He recommended exploiting that confusion deliberately. That is the document. That is the strategy. Published in 1988 in plain text by the person who coined the term as a legislative tool. Now let me give you the distinction that matters most in this entire area of the law, and that most media coverage consistently gets wrong. An assault rifle has a real, agreed legal definition. A selective fire infantry rifle capable of firing in both semi-automatic mode and automatic mode. The M16, the M4, the AK-47 in its military configuration. Weapons capable of automatic fire are classified under federal law as machine guns, regulated under the National Firearms Act since 1934, and effectively banned for new civilian manufacture since the Hughes Amendment to the Firearm Owners Protection Act in 1986. No ordinary gun store sells new automatic weapons to civilians. That market closed in 1986. An assault weapon, as the term is used in civilian gun law, means something entirely different. It is not a functional category. It is not defined by how the firearm operates mechanically. It is a political and legislative category defined by external cosmetic features, things like pistol grips, folding stocks, and flash suppressors, rather than by whether the firearm fires automatically, how powerful its cartridge is, or how fast it can cycle. The same cartridge, the same operating mechanism, the same rate of fire. A rifle can be an assault weapon in California, and a standard semi-automatic rifle in Texas based solely on whether it has a particular grip configuration. That definitional structure did not arise by accident. It arose in California in 1989. A mass shooting in Stockton, California involving an AK-47 variant spurred the state to pass the Roberti-Roos Assault Weapons Control Act, the first assault weapon ban in American history. That law pioneered the method of defining a prohibited firearm not by its caliber or internal mechanism, but by its external features and specific model name. California in 1989 invented the feature-based definitional approach that every subsequent assault weapon ban in the country has either copied or modified. That includes the 1994 federal ban. In 1994, President Clinton signed the Public Safety and Recreational Firearms Use Protection Act as part of the broader Violent Crime Control and Law Enforcement Act. The 1994 federal ban defined semi-automatic assault weapon in two tiers. Tier 1, 19 specifically named firearm models, AR-15 variants, AK-47 variants, and similar weapons were prohibited by name regardless of their features. If the model name appeared on the list, the firearm was banned. Tier 2, any semi-automatic rifle capable of accepting a detachable magazine that also possessed two or more prohibited features from a specified list. The prohibited features were a pistol grip that protrudes conspicuously below the action, a folding or telescoping stock, a bayonet mount, a flash suppressor or threaded barrel capable of accepting one, and a grenade launcher mount. Two features plus detachable magazine capacity equaled a prohibited weapon. The two-feature structure created the compliance workaround immediately, before the ink on the statute was dry. If the prohibition required two features, removing one feature from the configuration removed the rifle from the definition entirely. A rifle with a fixed stock and a pistol grip, or with a folding stock and no pistol grip, was legal under the federal ban even if it was mechanically identical to a prohibited configuration in every other respect. The featureless rifle was born as a market response to the two-feature test within months of the ban's enactment. The 1994 ban also prohibited the transfer and possession of any large-capacity ammunition feeding device, defined as any magazine capable of accepting more than 10 rounds. Magazines manufactured before September 13, 1994 were grandfathered. The ban was enacted with a built-in 10-year expiration date, a sunset clause inserted as a concession to secure enough votes for passage. Congress committed to studying the ban's impact on crime during those 10 years. By 2004, when the expiration date arrived, Republicans controlled both chambers. The political calculus had shifted. The studies produced inconclusive results on whether the ban had reduced crime rates meaningfully. Congress declined to renew it. The federal assault weapon ban expired on September 13, 2004, without a replacement. No federal definition of assault weapon has been in enforceable law since. What filled the vacuum was a patchwork of state-level definitions, each one constructed independently, each one drawing on the 1994 federal language in different ways, producing a definitional map where the same rifle can be a felony in one state and unremarkable property in the next. Let me walk you through 6 of those state definitions side by side, because this comparison is the most practically useful thing this video can give you, and it is the comparison that reveals why the definitional problem is as serious as it is. Before I do, let me establish the key analytical variable that splits the states into two camps: the number of prohibited features required to trigger the ban. One feature test states, a semi-automatic rifle with a detachable magazine is prohibited if it has any one prohibited feature. One feature is enough. This is the most restrictive definitional approach. Two-feature test states and named list states. A semi-automatic rifle is prohibited only if it has two or more prohibited features, or if it appears on a specific named list. Fewer rifles fall within the prohibition. The featureless workaround is available. California uses the one-feature test. Any semi-automatic centerfire rifle that can accept a detachable magazine and has any one of a specified list of features is an assault weapon. The list includes a pistol grip that protrudes conspicuously below the action, a thumbhole stock, a folding or telescoping stock, a grenade or flare launcher, a flash suppressor, or a forward pistol grip. One feature. That is the threshold. The featureless configuration, a rifle with a fixed stock and no pistol grip or other prohibited feature, is how California gun owners legally keep their rifles off the prohibited list. California also maintains named model prohibitions and covers specific configurations of pistols and shotguns. New York's SAFE Act uses a one-feature test as well. Any semi-automatic rifle that can accept a detachable magazine and has any one of the following is an assault weapon: a folding or telescoping stock, a pistol grip, a thumbhole stock, a second hand grip or protruding grip, a bayonet mount, a flash suppressor, a muzzle brake, a muzzle compensator, or a threaded barrel. The list is longer than California's. One feature still triggers it. Connecticut uses a one-feature test plus specifically named models. Either the model name appears on the list or the rifle has any one prohibited feature on a detachable magazine semi-automatic platform. Maryland takes a fundamentally different approach. Maryland prohibits specific named assault long guns, a list of 45 models, but does not apply a feature test to rifles. A rifle not on the named list and not a copycat of a named model is not covered by Maryland's rifle ban, regardless of what features it has. This is a model-based approach rather than a feature-based one. It means that a rifle with a pistol grip, a folding stock, and a flash suppressor, a configuration that would be prohibited in California after the first feature, is legal in Maryland if the model does not appear on the named list. New Jersey uses a hybrid approach, named models plus a one-feature test. Any semi-automatic rifle with a fixed magazine of more than 15 rounds, or with a detachable magazine plus any one feature from a specified list, is prohibited. Massachusetts mirrors the 1994 federal ban language in its statute, which would suggest a two-feature test. But in 2016, Attorney General Maura Healey issued an enforcement notice extending the ban to copies or duplicates of named weapons, interpreting the statutory language more broadly than the text itself. That enforcement notice effectively expanded the ban beyond what the legislature enacted without a legislative act, and it became the subject of its own litigation. Massachusetts represents a third definitional category, statutory language plus regulatory interpretation that extends beyond it. Illinois enacted its statewide ban in 2023 through the Protect Illinois Communities Act. Illinois covers semi-automatic rifles with a fixed magazine over 10 rounds, or a detachable magazine combined with any one feature from a list. Now read those 6 definitions back. California bans by one feature. Maryland bans by model name. New Jersey bans by one feature or named model. Massachusetts bans by statute plus AG interpretation. Connecticut bans by one feature or named model. Illinois bans by one feature plus detachable magazine capacity. The exact same rifle, an AR-15 with a pistol grip and a fixed stock, no other prohibited features, is prohibited in California after the first feature, legal in Maryland if the model is not on the named list, prohibited in New Jersey after the first feature, and prohibited in Illinois after the first feature. For a gun owner who travels across state lines with a rifle in a vehicle, the compliance analysis requires checking each state's specific statutory definition independently. A summary of, "Is this an assault weapon?" is not a legally sufficient answer. The question has to be, is this specific rifle, with these specific features, prohibited under this specific state's statutory definition? Now let me connect this definitional chaos to the constitutional argument, because this is where the definitional problem stops being a legislative inconvenience and starts being a structural weakness in the government's legal position. The Supreme Court in Viramontes versus Cook County and Grant versus Higgins will decide whether the Second Amendment protects AR-15 platform and similar semi-automatic rifles. The question presented to the court, whether the Second and 14th Amendments guarantee the right to possess AR-15 platform and similar semi-automatic rifles. That is the constitutional question. But embedded inside it is a definitional question the court cannot avoid. The Seventh Circuit in Beavis versus City of Naperville, the 2023 decision that directly generated Viramontes, held that AR-style rifles are not materially different from M16 rifles used in military capacities, and that therefore they lie outside the class of arms protected by the Second Amendment. The court defined the AR-15 primarily by its military design heritage, not by how it functions in civilian hands, not by how many are owned, not by what purposes they serve, by its relationship to the M16. The Supreme Court is now reviewing that definitional framework directly, and the definitional inconsistency across 11 states is part of the problem the court has to solve, not just a background fact about the legal landscape. Here is why. Under the Bruin test, the government bears the burden at step 2 of identifying a well-established historical tradition of the specific type of restriction being challenged. That burden is not satisfied generically. It must be satisfied for the specific regulation at issue. Cook County's ordinance defines assault weapons as semi-automatic rifles with the capacity to accept large capacity magazines and other potential modifications such as a pistol grip or muzzle brake, plus specifically enumerated models. Connecticut's ban uses a different feature set with a different threshold. These are not minor variations on the same law. They are fundamentally different statutory schemes purporting to regulate the same constitutional category. If the Supreme Court holds that the AR-15 is constitutionally protected because it is in common use for lawful purposes, it will also need to address whether states can use feature-based restrictions to functionally prohibit the same rifle under a different definitional architecture. A ruling that says the AR-15 is constitutionally protected does not automatically invalidate a state ban on any rifle with a pistol grip plus detachable magazine, unless the court also addresses whether the feature test, the definitional mechanism itself, survives constitutional scrutiny. That is the deeper question in Viramontes. Not just whether the AR-15 is protected, but whether the feature-based definitional approach, the method every assault weapon ban in America uses to define what it prohibits, is a constitutionally permissible way to regulate arms that the Second Amendment might otherwise protect. The government's best argument is the one the Seventh Circuit accepted, that AR-15 platform rifles bear sufficient resemblance to the M16 to fall within the military weapons carve-out Justice Scalia identified in Heller, weapons most useful in military service. If that argument prevails, the definitional inconsistency between states becomes less important, because the constitutional category is defined by the weapon's relationship to military use, not by its cosmetic features. The plaintiff's best argument is the common use standard: 30 million AR-15 platform rifles in civilian hands, used for self-defense, hunting, sport shooting, and training. Under Heller, that prevalence satisfies the common use test regardless of what features the rifles have or what they superficially resemble. If that argument prevails, feature-based bans fall not because of how they define their target, but because the target itself is constitutionally protected. Let me close with what this means for gun owners right now. There is no federal assault weapon ban in force. What governs your rifle is your state's specific statutory definition. And that definition varies enough between states that a general summary of what counts as an assault weapon is not legally adequate guidance for compliance purposes. If you are a gun owner in one of the 11 banned states, California, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, New York, Oregon, or Washington, plus Rhode Island, whose ban took effect July 1st, 2026, plus Virginia, whose ban is currently blocked by preliminary injunctions, your compliance obligation is determined by your state's specific feature test or named model list. Not by a concept, not by a general description, by the actual statutory text of your state's law and how courts in your state have interpreted it. A featureless configuration that is compliant in California may not be compliant in Connecticut. A rifle legal in Maryland may be prohibited in New Jersey. Check the statute, not the headline. The Viramontes cert grant changes nothing about your current compliance obligations. Every assault weapon ban in every banned state remains fully in force. The Supreme Court's agreement to hear the case does not suspend enforcement of any existing law. Do not act on anticipated outcomes from a case that has not yet been argued, let alone decided. What will change? By June 2027, when the court's decision is expected, is whether the Second Amendment permits any state to ban a semi-automatic rifle based on its cosmetic features, its model name, or its relationship to military design heritage. The answer to that question will determine whether the feature-based definitional approach survives at all, or whether 37 years of assault weapon ban legislation, built on a term that was invented in 1988 as a political strategy and has never had a consistent legal definition, finally meets a constitutional limit it cannot survive.